Welcome to NASET's first ever education landscape briefing. And we're thrilled to see the hundreds of members and special education professionals joining us. So tonight we're thrilled to welcome Dr. Alan G. Osborne Jr. and Dr. Charles J. Russo. They will offer us a 20-minute overview of the current special education landscape.
First of all, what the IDEA mandates is a free, appropriate public education in the least restrictive environment for all students with disabilities between the ages of 3 and 21. What it requires school personnel to do in conjunction with the parents is to develop an individual education program for all students with disabilities who qualify. And one thing that's very unique about the IDEA that had not been brought up in previous legislation at all is that it has a very elaborate due process procedure to protect the rights of students and, most importantly, to help settle any disputes that occur. One is an early First Circuit case, Timothy S. That has established the idea of zero reject, which simply means that no student can be denied services because their disabilities are so severe that they cannot benefit from education. The first case that came before the U.S. Supreme Court, the Rowley case, first of all, the court said the IEP itself has to be developed in conformance with the IDEA's procedures. And secondly, it must be reasonably calculated to confer some educational benefit.
Amy Rowley as a child, and there's a real good book. Amy was very hard of hearing, but she was getting along. She did pretty well. And she didn't come quite out and say, but I asked her whether she was the right plaintiff, and she pretty much intimated that she was not. They should have gotten a student who did not do as reasonably well as she did. She's now Amy Rowley, PhD. She works with and teaches college courses in the San Francisco Bay Area.
And that's actually pretty much, I think, what happened in Endrew F is they had a student who basically struggled quite a bit more than Amy struggled in class. And at this point, the Supreme Court indicated that, trivial educational benefit is not enough. The IEP has to aim to allow the child to make progress. And it has to contemplate an educational program that's reasonably calculated to enable the child to make progress, appropriate in light of the child's circumstances. There are a couple of conditions when it comes to age 21 brings you right up until your 22nd birthday. Some states don't offer general education classes up until that point. Some states do offer adult education programs for students who do not have a high school diploma but are over the age of 18. That you also must provide a free, appropriate public education to students with disabilities beyond the age of 18 if these adult education programs are publicly funded. Even if they're not necessarily offered, students in that state are entitled to a free, appropriate public education up to the same age as students who might be in adult ed programs, or 22, whichever comes first. GED diploma was not equivalent to a standard high school diploma because the GED was not fully aligned with the state's curriculum. So many states have very high standards, and the GED doesn't necessarily reflect those standards. So it's something to keep an eye out on. Many school districts, many states have dual enrollment, dual credit programs whereby students who are enrolled in high school can take college courses and they get credit basically towards their high school graduation. But also when they go on to college, they start off with a few college credits to begin with. This is going to vary depending on the state. Involved a student who had some medical issues. And because of those medical issues, she really couldn't come to school before noontime. She needed to have a program that started in the early afternoon, but not necessarily ended at 2 o'clock. IEPs have to be developed to meet the unique needs of each child. You don't fit the child into the existing programs that you have. So in the same way that many courts in the earlier days of IDEA were ruling that students with disabilities if necessary, had to have extended school year programs. Students also may be entitled to programming beyond the normal school day if that's what they need. In most states, when students reach the age of 18, we call the age of majority, which means basically they can make their own decisions. These students can sign their own IEPs. They have all the rights of their parents, unless they've been adjudicated as incompetent. But there was a situation that actually involved a student who was incarcerated. He challenged the services he was getting, and he won in due process hearings. And then he filed suit to recover his legal costs, his attorney fees. The lower court denied it, and they said only a prevailing party who is a parent of a student with disabilities can sue to recover attorney's fees. But the Second Circuit ruled otherwise. They said no. Students with disabilities who require it must be provided with special transportation. Transportation is more than a bus ride. In this particular case, the student lived in an apartment building that was not accessible and did not have elevators. The student was wheelchair bound. The school board refused to provide that service, and the parent challenged it, and the parent won. They can't benefit from their IEPs or from special education if they can't get there. There are cases from years ago that make it very clear that parents, if they need to, must be allowed to audio record IEP meetings, and that's pretty common now, particularly if it's necessary for them to fully understand the proceedings and fully participate in the proceedings. But this father claimed he needed to video record. Audio recording wasn't sufficient. The First Circuit did not agree with him. The father did not file suit under the IDEA. He filed suit under the First Amendment. He claimed he had a free speech right. The First Amendment doesn't give you any right to video record the meeting. They also saw that the IEP team's refusal to allow the recording was related very much to its interest in promoting candid conversations regarding the development of the IEPs. It involves the situation of a parent that really did not cooperate with the IEP process, but then enrolled the child in a non-public school. But what the court ruled is the school board and the IEP team were unable to provide an appropriate IEP was because of the parents' lack of cooperation. The parents stymied their efforts, and the fault was not the IEP teams, but was the fault of the parent. And for that reason, they denied reimbursement.